Good morning. It's the appointed time. We have a quorum. Let's invite representatives of the administration to come inside the conference room. Let's not waste time. This is the fourth meeting of the Bills Committee on Marine Safety, Alcohol and Drugs Bill. Agenda item number 1, meeting with the administration. I will not read out in detail the relevant documents. We have the representatives of the administration coming inside the conference room. And on 8th of April, during the Bills Committee meeting on that day, we have been scrutinizing Clause 13. The administration also gave a response to issues raised at the meeting on that day. It has been circulated among members. I would like to invite representatives of the administration to brief members on the response. I will also allow members to follow up on the response given by the administration, and then we'll move on to the scrutiny of Clause 14. Chair, good morning. Since the meeting on the 8th of April, on 17th of April, we have provided a response to the issues raised at the meeting on that day. On hospital patients, it means a patient receiving treatment at a hospital. The Clause 13 will provide protection to a hospital patient undergoing treatment in a hospital. For someone who is taking medication prescribed by the hospital and the patient is required to provide specimens of breath, blood, or urine, when the patient has left the hospital, Clause 13 will not be applicable. Also, Clause 13 applies to a situation where the person from whom the specimen is requested, that is the suspect, is in need of immediate medical treatment in the hospital and is capable of giving a valid consent to the provision of the specimen. Generally speaking, if a suspect is in need of medical treatment, the law enforcement agencies will immediately send the suspect to a hospital for treatment in order to safeguard the suspect's life and health. To obtain a specimen of breath, blood, or urine from the suspect, an authorized officer must notify the attending doctor of the relevant specimen provision request in the hospital where the suspect is located. After the attending doctor has consented to such a request, an authorized officer will require the suspect to provide a specimen. If the patient cannot give consent, the authorized officer can make use of Section 11(3), asking the attending doctor without the suspect's consent to take a specimen from them. And on Section 39E of Chapter 374, the police says that they do not have the relevant figures. And we believe the drafting is easy to comprehend and reflects the policy intent clearly. It is also reasonable and logical compared to Section 39E of Chapter 374. We believe, therefore, the drafting of Clause 13 of the bill right now is appropriate. I welcome questions from members and any comments that they may make. Thank you. I believe it would not relate to Section 11(4), and the administration, as said, has given a response to issues raised at 8th of April. If there are no any questions, we will move on to Clause 14. No other questions for Clause 13, correct, right? Well, I think now we're aware of the definition of hospital patients. Thank you. Thank you, Chair. Clause 14. It is about the documents, that is the giving of evidence that a specimen of urine or blood was taken, or in the case of blood subjected to a laboratory test. It has referred to the relevant sections in Chapter 374, and the arrangements are the same. Excuse me. Deputy Secretary, I did not read the form. What do you mean, the person? Who is the person? The suspect. But if they are unconscious, is it the case that you wait until they become conscious? Well, we have followed the drafting of Chapter 374. If a suspect is unconscious in a hospital, we have to seek consent from the attending doctor for the taking of the specimen. So it is either the medical practitioner, the registered nurse, or the enrolled nurse, and then they would have to sign a document. Is it just the attending doctor that would have to sign the document, or all of them? Well, for 14(2), it can be either the medical practitioner, the registered nurse, or the enrolled nurse, so it would just be one. Yes. Excuse me. I saw that someone has raised their hand, Mr. Lee Chen-kung. Well, I've pressed the button anyways. I would like to speak on Clause 14, but I would like to echo on the point that I made for the scrutiny of Clause 13. That is, how will it relate to the 13th clause? Well, it is about the evidence in relation to the specimen, Clause 14. Alright, so for a specimen of blood or urine, especially blood, we do not have a medical practitioner, registered nurse, or an enrolled nurse on a vessel, right, when the relevant enforcement agency is taking enforcement action. Is it the case that the specimen would only have to be taken after they have come ashore? Because it has been quite some time. Will the specimen still be valid? Well, we are following Section 10(7), as we said then. When we take a specimen, we would have to conform to a time requirement. It depends on which specimen it is. If it is a blood specimen or a urine specimen, we can have the specimen taken at a designated test center or a hospital or a police station. We already have the relevant timing requirement in the bill. I want to ask, in the waters of Hong Kong, how long will the journey take in general, and what is the maximum time required? That is for one to get from a vessel to a hospital or a testing center or a police station. I think we can have someone from the Marine Department answer this. Well, thank you, Chair. Excuse me. Mr. Lee. Oh, sorry, I got your name wrong. It's too early in the morning. On Clause 14, apart from medical practitioner, we can also have an authorized officer take a specimen, and it can be an authorized officer of the Marine Department. And we have taken specimens before on vessels, and if specimens are indeed taken on vessels, it would be an authorized officer that would sign the document, so we can show that a specimen is taken from the individual. Well, I have no problem with 14(1), but for 14(2), it cannot be some officer that would sign the document. Would that be a problem? Well, for a specimen of blood, we will not take such specimens from vessels because we must have a medical practitioner or a nurse take the specimen, so we are not qualified to take the specimens. Okay, thank you. Well, any other questions? If not, please proceed. Clause 15 provides for the giving and admissibility of evidence of the proportion of alcohol in a specimen breath, blood, or urine. It refers to Section 39C of Chapter 374. And the arrangements here are the same as those in Chapter 374. Mr. Rincon. Chair, I want to ask about brackets 5. I understand that it is, well, 15 brackets 5 you were referring to. Yes. That is evidence of the proportion of alcohol in a specimen of breath, blood, or urine provided by a person is evidence that the proportion of alcohol in the person's breath, blood, or urine at the time of the alleged offense was not less than in the specimen. I find it interesting. Why is the drafting not the same as instead here it is not less than? Shouldn't it be equivalent? I understand that this is the same as that provided in Chapter 374. Well, I think it is very technical. It may be difficult to explain, but we'll wait for the administration to provide a response. Yes, I want to know what the reasoning is behind this. Well, let me try to explain. It is because when the incident happened, or when the specimen is taken, after that it has been a certain period of time and some of the alcohol in the body has been metabolized, so the level will be lower. I think Mr. Rincon asked a good question. Let's assume that when the specimen was first taken, or right before that they have just consumed alcohol, would it affect the prosecution of such individual? I think Mr. Rincong's question is quite valid. So essentially, when someone drinks, they can actually fight off the charge by doing so. Is that what you meant, Mr. Rincon? I just don't quite understand. So you have the specimen. I think it is very important to clarify this because Clause 15 relates to evidence in relation to alcohol in specimen. So I don't really understand why they are saying here. Why not just use the specimen as evidence? Why do they have to say that the evidential proof it would not be not less than that in the specimen, the evidence of the proportion of alcohol? This is a matter of principle. That is, when you are saying this, basically it means you are, after you have taken the specimen, the reading will definitely be higher than that afterwards. Well, that should normally be the case when the suspect has consumed alcohol or drugs and then they were called by an authorized officer and had to take tests, and the taking of specimen may not be done immediately on the vessel. It may be afterwards at a hospital. So it is only normal the level will be lower than when the specimen was first taken. So it can most likely only be lower than the proportion of alcohol in the specimen. It should not be lower than that in the specimen. Excuse me.
Well, I'd like to follow up. Why do you have to write it this way? You kind of made a judgment. I don't understand why you have to make this judgment. Why do you have to write not less than? Why couldn't you just write equal to? This might be the case, but you can't rule out the possibility that For a particular type of drug, the content will go away after a certain period of time. You can't rule out this possibility. So why can't you put it this way? That is was equal to that in this specimen. Why do you have to make such a judgment that it was not less than that in this specimen? If you write it this way, you are subject to challenge. That's why I pointed out the fact that if someone has consumed alcohol after being caught, what will happen? Well, say if I drink drive and the content is over 25, over 22, say 50, but after being caught, I consume the whiskey again, then the reading will be higher than that taken on the spot. In the case of drugs, maybe the drugs have not kicked in yet. Then somebody is caught. Will it affect your prosecution? If it will affect your prosecution, maybe you have to make adjustments to this clause. Probably you have to back it up with some scientific principles. You need to show us these principles. Director of Marine. Thank you, Chairman. I'd like to take a look at this from another angle. In the execution of this section is actually on the spot. There is evidence showing that somebody cannot perform any designated duty or cannot operate a vessel that is underway. That is to say, at the time of the offense, we take this specimen. Then in accordance with subsection 5, according to what we understand, as Mr. Chen said, the alcoholic contents may go away inside somebody's body. When we take the concentration of the specimen, it is not less than that in the specimen. Because when we first take the specimen, we don't take the specimen right at that time of the offense. It probably, there is probably a time difference, say half an hour later. That explains why. Mr. Kong, in brief, well, I don't think this is fair. In subsection 4, you already said that in the certificate as to the proportion of alcohol found in the specimen of blood or urine identified in the certificate, that already serves as evidence. But in subsection 5, you said that the proportion of alcohol was not less than that in the specimen. It's you who makes the decision as to where the suspect will have to provide the specimens. You simply can make the judgment and write it down in subsection 5 that the specimen taken at the time of the offense is definitely higher than that taken later on. You can make this judgment. Well, Chairman, while I was introducing this subsection, is actually in line with subsection 12 of section 39C of Cap 374. Well, that's not a Bible. It can be wrong. Deputy Secretary, we understand that enforcement officers take these specimens as soon as possible. These will be tendered in court. So when enforcement officers intercept the suspect, probably the suspect has already consumed alcohol and half an hour has already passed. We don't know. We can only take the time when we catch the suspect. Sometimes we can take the specimen on the spot. Sometimes we need to wait until we move to another place before we can take the specimen. So that's why we said that we will do that as soon as possible or as practicable. But we can make sure we can do it every single time on the spot. Mr. Kong, can the administration show us the evidential principle in other overseas jurisdictions? Can you give us written replies? I'd like to know whether this is reasonable. Thank you, Chairman. Maybe the administration can go back and take a look at it, and then they can provide us with supplementary information. Provided by a person is evidence that the proportion of alcohol in the person's breath, blood, or urine at the time of the alleged offense was not less than that in the specimen. Well, this is absolute. Maybe the administration can look into it and give us supplementary information. Any more questions? If no, let's move on to subsection 6. Well, I mean section 16, subsection 3. A person is under the influence of a specified illicit drug to such an extent as to be incapable of having proper control of a vessel if A. the person's ability to operate the vessel properly is for the time being impaired, and B. the concentration of a specified illicit drug or of a combination of specified illicit drugs found in a person's blood or urine would usually result in the person being unable to operate a vessel properly. We drew reference from Section 39J under Cap 374. We didn't specify performing under designated duty or operating a vessel underway is illegal. We have already drawn reference from the Crimes Ordinance Cap 200. That person will already be deemed as having the intention to commit a crime. Even if a person is not charged with the offense of intending to do something or intending to commit a crime, that person can still be convicted. So we do not need to add the words intention or intend to. Members, any question? It's clear, right? Let's move on. Section 17, it's similar to Section 16. It provides a person must not operate a vessel that is underway while any concentration of a specified illicit drug with or without any other drug is present in the person's blood or urine. That is illegal. Likewise, we do not have to prove that a person is performing or fails to perform any designated duty or operates any vessel that is underway. That person can still be convicted. We have drawn reference from Section 39K brackets 1 brackets 6 under Cap 374. Mr. Kong, I understand Section 16. Section 17 refers to performing any designated duty. As to Section 16, subsection 5, the penalties are the same as those in Section 17, subsection 3. What is different is subsection 4. Section 16, subsection 6, and Section 17, subsection 4, they are different. Section 17, subsection 4, it's more lenient. In Section 16, subsection 6, the disqualification will last for 5 years or up to 10 years, whereas in Section 17, subsection 4, the disqualification will last between 2 years and 5 years. I don't understand. Why is the penalty under Section 17 more lenient than that in Section 16, subsection 6? Why is that the case? I don't quite understand. Mr. Chan? Thank you, Mr. Kong. The two provisions are different. In Section 16, it means somebody has already consumed illicit drugs and the ability is already impaired. However, in Section 17, subsection 4, it simply means that a certain concentration or content is found inside the body of someone operating the vessel. It does not mean that the ability is impaired. In Section 17, it simply means somebody has consumed drugs. It does not mean that the ability has been impaired. That's the difference. Thank you. I understand that. Well, why can the penalty in Section 17, subsection 3 be more lenient? The administration's reply is very good. Section 16, illicit drugs. Somebody knows that he or she cannot operate a vessel, whereas in Section 17 it refers to the concentration. So I don't understand why the penalty under subsection 3 of Section 17 is so heavy. I don't quite understand. Administration? Excuse me, Mr. Kong. Can you tell us more clearly? What is your question? Well, there's the penalties under Section 16 and Section 17 are the same. The penalties under Section 17 bracket 3 are the same as Section 16 bracket 5. However, when it comes to the period of disqualification, why are the periods different? If Section 16 is less serious than Section 16, that does not make sense to me. Mr. Kong is referring to disqualification and imprisonment. The terms of imprisonment are the same under Section 16 and Section 17, whereas for the disqualification order, the periods are different. They are different under Section 16 and Section 17. Do you understand now? Thank you.
I'll try to respond to Mr. Kong's inquiries. That is, for Clause 16, it is about someone who has taken drugs and has been performing a duty or is in control of a vessel. But for Clause 17, it may be about someone who is not performing a duty or operating a vessel. For a specified illicit drug, it will be the same as that of subsection 3 in both clauses 16 and 17. But for subclause 4, because one may not be operating a vessel or performing any designated duty in Clause 17, that's why a lighter punishment in relation to disqualification will be punished. So for a judge, it may be that it will be a less harsh punishment. Sorry, I disagree. Clauses 16 and 17 are very similar, and we're just trying to look for the minor differences here. Clause 16's definition is under the influence, and for Clause 17, it would be about the concentration. Why are such minor differences? cause the difference in the disqualification. Both clauses 16 and 17 are quite serious. Why is there a difference for disqualification? And I would hazard to say that for clause 17, this minor differences indeed justify a significant difference for the penalties in relation to disqualification. Well, I think the administration can take note of this and think if any amendments have to be proposed. So let's end it here for now. Let's move on to clause 18. Clause 18 creates the offenses of operating a vessel or performing any designated duty under the influence of a non-specified drug to an extent that makes the person incapable of having proper control of the vessel or performing this designated duty properly on board the vessel. It has again referred to the Road Traffic Ordinance, Chapter 334, when drafting this, and the penalties are the same. Mr. Rincon, on clause 18 brackets 5, for the consumption of non-specified drugs and the specified illicit drugs, they have the same penalties. It is unfair because when one has just taken flu medication, they would get the same penalties as someone who has taken specified illicit drug. But they did provide for larger punishment in relation to disqualification. So we can see that with the penalties for disqualification, going from clause 16, 17, and then 18, it is getting lighter, but then they would still receive the same prison sentence. Well, let me say that for clauses 17 and 18, it would make sense because clause 17 relates to a specified illicit drug, while clause 18 relates to a non-specified drug. So for the penalties for specified illicit drugs, for the disqualification penalties, it would be more serious. I think it is because both would have someone who is incapable of having proper control of the vessel or performing the designated duty properly. So they have the same prison sentence, but they do see that there is a difference between the specified illicit drug and the non-specified drug, which is why they have the difference in penalties for disqualification. Clause 16 relates to someone who has consumed a specified illicit drug and has been operating a vessel. Clause 17 relates to someone who has taken a specified illicit drug but is not in operation of a vessel or performing a duty, while clause 18 relates to someone who has taken a non-specified drug. Well, I think the administration can perhaps provide a reply to this after the meeting. Mr. Lee Chen-kung, I think let's take the example of someone who has taken a flu medication. What is going to happen? Is it the case that they should get someone immediately to replace him? Operational matters, Deputy Secretary, please. Well, when we get to clause 17, we'll have a defense or defenses set out. So we have either the drug that was lawfully obtained, so flu medication would be that of medication that is lawfully obtained, and that someone is not aware of the fact that after they have taken the medication, they will be incapable of operating the vessel. Because when someone gets a medication that is prescribed by a doctor, it may not be the fact that everyone's reaction would be the same. So I think we can get to clause 20 and we can explain in detail on these. If we are to have any division of labor, if one is to take medication, the master should coordinate with them crew members. If there won't be enough crew members to take over, then the master should not set sail at all. Yes, Mr. Chen Xiu-hong. I understand the administration has provided a response to the previous issues raised, but I want to ask, so the administration has referred to the road traffic ordinance when drafting this bill. When one's ability is impaired by alcohol or drugs and then operates a vessel and then endangers someone's life or property, it should be more serious when someone has taken a specified illicit drug than when someone takes a non-specified drug. For someone who has taken a non-specified drug, they should be punished, but they should receive a lighter punishment. It also depends on whether someone is operating a vessel and then was caught. If someone is only on duty but is not in operation of the vessel, that is, one may be working in other posts, and one's concentration is over the prescribed limit, then one should be punished, yes, because that is the policy intent. So I want to ask though, why is it the case that they have the same penalties? I do see the word may that is used here. So is it the case that the judge would still have discretion as to these different cases depending on the seriousness? I do see there are differences with the disqualification periods. It does say specifically for the disqualification penalties that one would receive a more serious punishment. For example, for clause 16, it would be 5 to 10 years of disqualification depending on the circumstances. So the judge had no choice, for example, to hand out the punishment in the relevant clauses. That is, for clause 17, it would be some years, but it would be less than that of clause 16. I just want to understand the logic behind this. Well, the literal understanding is that the judge must hand out such disqualification periods. Is that right, Deputy Secretary? I don't want this to get any prolonged discussions because I think the questions are very similar. Chair, for the three clauses 16 to 18, are of similar offenses. Because the seriousness is different, that's why we have different disqualification periods. So for clause 16, it would be someone who has consumed alcohol or specified illicit drug and is operating a vessel. For clause 17, it would be about someone who has consume the relevant substances without operating the vessel, whereas for clause 18 it would be about someone who has consumed a non-specified drug. So indeed, the disqualification periods are different, but the prison sentences and the fines are the same. But we have set out a range for the disqualification penalties, but then the judges can make a discretion as to which disqualification period to impose within that range. Thank you. Let me add something. Yes, Director of Marine. We have imposed that the court or the magistrate may, for special reasons, order that the person be disqualified for a shorter period or that the person not be disqualified. So it can be less than that range, or someone may not be disqualified at all. Thank you. All right, let's move on to clause 19. It is about defenses for offense under section 16 or 17, as said, if the specified illicit drug was lawfully obtained, or when the person did not know or could not reasonably have known, if consumed or used in accordance with advice, the drug would render the person incapable of having proper control of the vessel or performing the designated duty properly. And or 3, the person consumed or used the drug or the combination of drugs in accordance with the advice. We have also referred to the relevant provisions in Chapter 374 when drafting this. Thank you. Mr. Kong, I have a minor question. I want to ask about advice in 19 brackets 4. Yes, we are on clause 19, right? Yes. So when we're talking about written or oral advice, for oral advice in particular, how will one be able to prove this? Isn't it the case that we would often have written prescription for medication? If we're allowing for oral advice, it will be very easy for a suspect to kind of coordinate with a medical practitioner to say that there has been oral advice when prescribing the medication. Correct, Deputy Secretary? Well, we have 4 types of healthcare professionals as said below. They are regulated by professional associations, so whether written or oral, we believe the advice is very much real. If there is any false instrument involved or if there is any false evidence given, the professionals will be followed up on in other investigations. Thank you.
Another factor is that the healthcare professional concerned may not be in Hong Kong. Can I take it that way? Probably the seafarer is an overseas seafarer, and probably the medication is prescribed by an overseas medical practitioner, and the advice may not be a written one. Can I take it this way? Yes, in Hong Kong that could be the case, but if we rely too much on the written prescription in case of any delay, that will be a great loophole. Mr. Kong, well, Chairman, that will be a great loophole. We are going to talk about heroin in the later sections. The administration Deputy Secretary. Thank you, Chairman. Some drugs are very common drugs that we know we shouldn't consume. But in some cases, some drugs are prescribed by doctors, by medical practitioners. That is also possible. Mr. Kong, I have something to add. If we need to draft a piece of good legislation to safeguard the safety of people on the sea, we need to only accept written form. Chairman, just now you made a very good point. A seafarer may be an overseas seafarer, so how can you prove that he or she has a verbal advice? That is a significant loophole indeed. In my experience, providing written advice is not totally viable. Things are in a state of flux at sea. It's always constantly changing. In developing countries, the situation is different. So, in my opinion, medical practitioners should be subject to regulation or monitoring of their quality. Regarding the written or verbal advice, I'll ask the administration to conduct risk assessments. I'm not saying this is totally wrong or it's right, but the administration should look into that and conduct risk assessments. Mr. Lee Chun-kung, I'd like to ask about medical practitioners under healthcare professionals. Do Chinese medical practitioners, are they involved? What about registered dentists? What about overseas registered dentists? If a local registered dentist is also counted, what about an overseas registered dentist? Is that covered? Deputy Secretary. Thank you, Chairman. Well, one can claim one is a medical practitioner if one is not one. In Cap 1 of the laws of Hong Kong, there is a clear definition of healthcare professional. It's also applicable to this new legislation regarding registered dentists. In Section 2, Subsection 1, there's also a definition over there. Let me check. I'm looking for the Chinese version. It has the meaning given by Section 2, Brackets 1 of the Dentist's Registration Ordinance, Cap 156. In other words, we have to refer to Cap 1 in relation to the definition of medical practitioners, whereas for the definition of a registered dentist, we can refer to the definition of a registered dentist under Section 2 of the bill. There is no definition of a registered dentist under Cap 1, so we have added this definition under Section 2. What about Chinese medicine practitioners? Are they covered? Well, under this bill, traditional Chinese practitioners are not covered. Any comments? Mr. Lee Chun-kung, you're saying that you have to follow Cap 1, but in the definition or in the interpretation, did you explain that? Will you consider setting it out that you will refer to Cap 1 when it comes to the definition of a medical practitioner? Mr. Alan Chong, in Section 19, healthcare professionals cover four main types, as in A to D. However, when we are going to scrutinize Section 20, which the administration will walk you through, these two sections are quite different, as in the next section you will see that Chinese medicine is covered. Mr. Wen Kong, is it the case that the illicit drugs cannot be prescribed by traditional Chinese medicine practitioners? Is that the case? They are not covered? Yes, that is correct. The medications are prescribed by Western medicine practitioners. Medical practitioners. Section 19 is similar to Section 20. Section 20 provides for the defense for offenses under Section 18. So in Section 20, subsection 2, we have drawn reference from subsection 10 and subsection 12 brackets 1 under Section 39L under Cap 374. Any question about Section 20? Mr. Rin Kong and Mr. Yim Kong. Mr. Rin Kong, I have a drafting recommendation. In Section 20, subsection 2A, a healthcare professional prescribes it for, or administers or supplies it to the person charged. Can we add or? That will be clearer. That is, either one will also fall under the scope. Can we put or, can we add or at the end of the subsection A? Well, it depends on the usual drafting method. Well, Mr. Rin Kong, do you mean between subsections A and B we should also add or? Let me explain it. Well, I think it should be either A or B or C. But if we do not add the word or after subsection A, that is not clear. And in subsection 2B, we can see and between subsections B1 and B2. So can we consider adding or at the end of subsection A? There's no impact on the legislation, but it will be clearer. I can add something. Thank you, Chairman. Mr. Alan Chong. In general, if there are parallel structures or paragraphs, we not only pay attention to the at the start of these sentences. If there's none, we will add the word or at the end of the paragraphs. Regarding subsection 2b, why is there the word and? That is because there are two conditions, one Romanian characters 1 and 2. These two conditions have to be met at the same time. There's connectivity between them, so the word and is used. In the second last paragraph, adding the word or is in line with the existing drafting of legislation. Well, thank you, but members of the public will not know. They can actually refer to that point to tell whether it's an or. Chairman, do you understand? Yes, I do understand what you mean, but it's been drafted in such a way. Sometimes it's B1 or 2 and something else. Well, Chairman, never mind, we can step up public education efforts. For me, I really don't understand, but we can step up publicity and public education. I think the administration should get the legislative intent clearer. If the word or is used to connect all these subsections, then members of the public will only have to refer to the last one. Mr. Alan Chong, yes, indeed. Public education is very important. There is a publication by the DOJ that is accessible online. Members of the public can access the relevant document. We use quite a coherent method to connect these subsections. In the laws of Hong Kong, the same set of standards is adopted, so it's kind of difficult to change the method of drafting just because of one single piece of legislation. Well, we can consider doing more on this front. Next member, Mr. Yim Kong. Thank you, Chairman. I'd like to talk about defenses. Is it possible that someone operating the vessel is having a flu or a fever, and probably that will make the driver drowsy? The doctor may say that the person is not fit for going to work. But what about a private pleasure boat? Maybe the boss needs to host an event and the boss can look for somebody else to stand in for that person. So the boss may still require the person to go to work on that day. They need to set sail. That person knows the situation. The doctor has already told him or her, but then the boss might threaten him or her with firing him or her. What about these cases? Thank you, Mr. Yim, for pointing this scenario out. This is exactly what our bill needs to prevent. If someone is under the influence of drugs or alcohol, so much so that he or she will undergo an impairment in the operation of a vessel, then that person should not operate a vessel. Otherwise, the safety of other persons will be affected. We actually mentioned this situation earlier on in our meetings. That is in relation to some employees working on board. Mr. Wong, Director of Marine, the bill is all about marine safety. If someone understands that someone cannot operate a vessel, then he or she should not operate the vessel. In cases like when he or she is fired, in my view, is that an argument? Is that a dispute between the two of them? I can't say that we are going to arrest the boss when a seafarer is found to be operating a vessel under the influence of alcohol or medications. Well, that is their responsibility overall. Yes, I understand what you mean. It's actually a professionalism as well, just like lawyers. If someone forces you to break the law, it's that very person who will have to face legal consequences after all. In case of labor law, probably that concerns another realm of law. Right now we're talking about marine safety. Mr. Lam and KK, a former legislator, also talked about unfair treatment of seafarers. I hope the administration will relate this phenomenon or this situation. That is, if someone is forced to drink drive or drive in the sea, what will happen? Thank you.
Mr. Ring Kong. Echoing on what Mr. Yim Kong said, for clause 20, if someone is drugged, what's going to happen? Will one have defense? I think that can be quite common. Someone was drugged unknowingly. It is possible, and clause 20 does not provide for such defense. Well, let me say this. Normally, one should be able to defend oneself by giving evidence on this, and the judge will see if they want to accept that. I think we cannot provide a concrete answer on this, unfortunately. Mr. Kong. Now, for clause 17, it relates to someone having a concentration of alcohol drugs in their body, and one would already be subject to prosecution. But for clause 20, it may be more complicated. Since we are already providing for the defenses, why not include someone who is drugged unknowingly, because it is involuntary. There were teenagers who went to some night entertainment venues and they were drugged. It's just on the news today in some French restaurants. They have asked visitors to be mindful of any potential drugging that may occur. So I think we should provide for this in clause 20. Well, let's see if any of the scenarios can be made applicable. The administration can respond to what Mr. Yin Kong asked for now. Mr. Chong, let me say this. For clause 20, the defenses are for defendants to raise a defense when they consume the drugs voluntarily. I do understand Mr. Yin Kong's concerns. The administration may not be able to provide a concrete answer right now, but in criminal law, the prosecution's division must prove all the elements of the offense. If one is drugged unknowingly and has caused some incident or an act to be performed, the defendant may be able or may not be able to raise defense, but we can study that. Let me say this. For someone who was supposed to give sugar to someone and they accidentally gave something else to that person would not be prosecuted. Is it the case? Because one thought they were consuming sugar. Well, I'm inclined to think the same, Chair. For one to prove all elements of the crime, there has to be mens rea and as well as actus reus. The prosecution must prove all of these elements. If one is not aware of this, then there may not be mens rea. But let me just say this may not be covered by this bill because such defenses are available to all or most crimes. So this will be included in a separate ordinance. Yes, indeed, because this would be made applicable to many crimes, which is why it may not be included in this bill, correct? Well, I actually want to talk about clause 19, Chair. I'm just concerned. I understand what Mr. Chong said. For someone who has been given drugs by another person, causing that someone to not be able to operate the vessel or perform duty on the vessel, the person who has drugged that person will not be liable under clauses 16 or 17. But for the person Well, let me just say this. If there is an incident and someone is injured or dead, the crimes ordinance, would that make someone, the one who drugged this master, liable? I know this is far reaching, but I want to make sure adequate protection is provided to the master. Would it be the case that the person should be held liable for manslaughter? Well, I think it should not be covered by this bill, Chair. I think your understanding is quite correct. What Mr. Kong said should be covered by other ordinances, because this bill only relates to marine safety. Chair, of course I understand, but we want to be comprehensive in the protection of marine safety. I hope the administration can review if the crimes ordinance is indeed adequate in preventing this. Alright, the administration can review this, perhaps consulting the Department of Justice or any relevant bureaus or departments on this. For someone who has drugged the master of a vessel and then causing an incident, this is endangerment to public safety. We should review this. I understand that this may not be covered by the bill, but perhaps the administration may provide a response at the next meeting. Let's move on to Clause 21. Thank you, Chair. Clause 21 relates to an offense under Section 17 or 18 instead of Section 16. That is, it makes an offense of Clause 17 or 18 a possible alternative conviction on the trial of an offense under Clause 16. For 21 brackets 3 and brackets 4 in particular, if on the trial of a person charged with an offense under Section 16 brackets 5 for contravening Section 16 brackets 1 or 2, the prosecution proves that the person operated or attempted to operate a vessel that was underway or performed or attempted to perform any designated duty, and the person was under the influence of a drug, not a specified illicit drug, to the extent as to be incapable of performing the designated duty properly or having proper control of the vessel, the person must be acquitted of the offense but may be found guilty of an offense under Section 18. Well, these are alternative offenses essentially. Alright, if there are no questions from members, let's move on to Clause 22. Thank you. This is similar to Clause 7. It provides for the sections 16 brackets 5, 17 brackets 3, or 18 brackets 5 alternative offenses. Well, Clause 22 is relatively simple. Any questions? Mr. Kong. Well, I am not a barrister, but I want to ask. So, I have looked at Chapter 548 and Chapter 313. They have quite heavy penalties. It would be $200,000 in fine, as well as 2 to 4 years of imprisonment. So when someone is charged, will they be given separate charges? If one is charged under this bill, will one have to be charged for these other ordinances, Chapter 548 or 1 and 3 at the same time? I think the DOJ should answer this. Yes, thank you, Chair. So for one who is charged under Section 16, 17, or 18 of this bill, if one is found not guilty but has found to be in violation of Chapter 548 or Chapter 313, the person may be convicted. As for how the charges are put, whether the prosecution's division would include that in the list of charges, I need to review that internally. But in general, for the bill, if someone is charged under Section 16, 17, or 18, the elements of the crimes for Chapter 548 or 313 are proved, then one may be convicted under Chapter 548 or 313. Chair, I have something to ask. If the crimes, the offenses are actually very similar indeed, as Mr. Chong put it, so I asked the administration to include all of these charges when charging someone. Otherwise, if one has to be charged on separate cases, it may be inefficient. Well, indeed, it is the case, because it would be inefficient if one has to start the proceedings all over to charge the person with another charge. Well, let me add something here. I think the bill's provisions mean that someone may be convicted of other offenses under the other ordinances. As for whether the prosecution has to include them when charging the defendant, it is another matter that we have to review. Thank you. Okay, let's move on to Clause 23. These are the processes for the preliminary drug tests. We have referred to Section 39M and 39O of Chapter 374 on this. Thank you. Members. Alright, let's move on. Clause 24 is similar to Clause 9 of the bill. For someone without reasonable excuse commits an offense when they fail to undergo or provide specimen for preliminary drug tests. Again, we have referred to Chapter 374. The arrangements are similar. Mr. Income, can the administration explain this? In 24 brackets 2, for someone who has failed to undergo or provide specimen for preliminary drug tests, their penalties are similar to those of someone who has been found to have their concentration or are found to have impaired ability to control the vessel or perform designated duty on the vessel. Can you be more clear? I want to know the policy intent of one failing to undergo or providing specimen for a preliminary drug test would have similar penalties as someone who has been found to have consumed excess drugs or alcohol. I understand what is going on, but I just want to be clear. Thank you, Chair. We just want to achieve a deterrent effect here. For someone who has failed to undergo or provide specimen for preliminary drug tests, they will have similar penalties as someone who has been found guilty for the other offenses. So we want people to provide specimens as required.
Right, if the penalties are lighter than the original offense, then this will be problematic. Next, Clause 25. It provides specimen for a laboratory test. We have drawn reference from Section 39P1 to 5, 7, 8 of Cap 374. Members, any question? It's about procedures. No problem. No question. Regarding Clause 26, it provides supplementary provision on specimen of blood for laboratory tests. We've drawn reference from Section 39P subsection 6, 9, and Section 39Q subsection 1 to 5 under Cap 374. Any question? Members, any question? No? Let's move on to Clause 27. It's similar to Clause 12 of the bill. It's about failure to provide specimen for or give consent to laboratory test. We have drawn reference from Section 39 as 1 to 4 and 7 under Cap 374. Members, any question? No question? Then, next clause, Clause 28, protection for hospital patients, is similar to Section 13 of the bill. If someone is a hospitable patient, the attending doctor needs to be notified before a sample is taken. That covers specimens of oral fluid, urine, and blood. Members, any question? It's similar to the ones we have taken a look at. Clause 29. Specimen may also be used to test for alcohol under Section 25 or 26. In our answer to the legal advisor, we already given some information. The principle is that too much blood should not be drawn as long as it is suitable or appropriate or enough. That is 2 samples of blood, each 10 milliliters. We have drawn reference from Section 39 or brackets 1 of Cap 374. The quantity isn't set out. It's actually the guidelines laid down by the government laboratory. What about any adjustments made by the government laboratory? You still stick to the same principle as long as it is sufficient or enough, then it will be fine. Is that correct? Well, we have to take a look at the adjustments. That's why I asked, who is to judge? Who is to decide enough? It's okay. Well, it's a government laboratory. For example, if 2 samples, each 5 ml, if that is sufficient, if that is enough, that will do. That is to say, that's the standard or guideline of the government laboratory. Is that correct? Yes, that is correct. Section 30 is similar to Section 14. It's about evidence in relation to specimens. We have drawn reference from Section 39P brackets 10 and 11 and Section 39Q brackets 6 and 7 of Cap 374. No question. Next clause, Clause 31, is similar to Clause 15 of the bill. It's about evidence in relation to drug in specimen. We have drawn reference from Section 39R brackets 2 to 7 under Cap 374. Members, any question? No question. Next clause, Clause 32, is about power to stop and board vessel. An authorized officer may at any time stop and board a vessel for requiring a person who has been operating or has been performing any designated duty on board the vessel that was underway to undergo a screening, breath test, or a preliminary drug test. Brackets 2. An authorized officer may at any time stop aboard a vessel for making any examination or investigation that may be necessary if two conditions. We have drawn reference from the relevant provisions under Cap 374. The penalties are the same. A fine at level 2. In clause 32 brackets 5, rather it should be subsection 4. I mean failing to obey subsection 4, that is in subsection 5, a person who without reasonable excuse contravenes subsection 4 commits an offense and is liable on conviction to a fine at level 2. In some other cases, if one does not stop the vessel, that is actually very serious. It is tantamount to damaging evidence. It's my suggestion or my view. Can you take a look at it? That's not proportionate. Mr. Rincon, I agree with you, Chairman. I suggest that the administration should consider in section 33. I mean, if someone does not help in the investigation, one should be liable to imprisonment of 6 months and to a fine of level 2. At least one needs to be imprisoned. It's not necessarily the master of the vessel that breaks the law. The seafarer may also break the law. If the seafarer breaks the law, he or she might be fined. May be liable on conviction to a fine at level 2. That's several hundred of dollars. Well, I do think you need to look at the proportionality of the offenses as well as the penalties. Yes, indeed, we'll take a look at it. Any question? No? Next. Clause 33. Power to investigate. During investigation, any part or any object on board must not be interfered with. Information must be provided by the suspect if so required. We have drawn reference from section 60 and section 61 under Cap 374. The penalties are the same. Mr. Rincon, I have a couple of points. In section 33, clause 33, 1D3, to ensure that it is available for use as evidence in any proceedings for an offense under this ordinance. However, in section 22, the other two ordinances are mentioned. They can be alternative offenses. So can we make it clear? That is the proceedings of those two ordinances. That is because you can charge a person for a couple of different acts based on different ordinances. So can the administration consider adding the said ordinances right here? Regarding E, when someone gets on board to make investigation, the officers will request people to provide information. So how can you make sure that these people can also seek legal advice on board? In clause 33, you did not mention that these people have the right to seek legal advice and they can remain silent. In F2, can we use the word check? C may have the meaning of just taking a look. It's quite strange to translate 查看 in Chinese into see in English. Thank you, Mr. Ring Kong. In clause 33, 1D3, Chairman, if you allow us to submit information after the meeting, we will do so. Regarding 1E, that is whether a person can stay silent, we will provide information after the meeting. That is a basic legal right unless otherwise specified. There may not be significant changes, but what about the word C? Mr. Alan Chong from the DOJ. Thank you, Chairman. Thank you, Mr. Ring Kong, for your question. I understand you have concerns as to whether the word C is the only option. We will look into that after the meeting and will also provide information. But we think it already serves the policy purpose, but we can look into it. No question. Next is a comment. Clause 34. Authorized officer may require certain information. For example, the particulars, the name, address of the master of the vessel or the person operating the vessel or performing any designated duty on board the vessel.
34條就主
Mr. Lam. Well, this clause is about authorized officers requiring information from individuals' name, address. The information can be provided after the fact in writing, but in 2B, it says that it should be within a reasonable time after the occurrence or alleged offense. A written statement should be provided. A reasonable time, I'm not sure what that is. If the time taken is indeed a bit too long, will it affect prosecution? In the road traffic ordinance, in general, they will ask information to be provided within, say, 21 days. So therefore want to ask what the reasonable time is. Thank you, administration. Well, the reasonable time really depend on the circumstances. I'll let colleagues of the Marine Department talk about what a reasonable time frame would be in general. Thank you. Thank you. Let me say this. For a local vessel, a reasonable time would be 2 weeks to 1 month. Outside of that, it would be unreasonable. This bill also is applicable to ocean-going vessels. We have to ask for information of the ship owner. The ship owner may not be local, it may be overseas. As long as justifications can be given to show that there is no intended delay, we can be flexible. That's why we are providing here a reasonable time to provide for some sort of flexibility. Mr. Lam, any follow-up? If not, let's move on to clause 35. Thank you, Chair. Clause 35 empowers an authorized officer to arrest and remove from vessel any person whom the officer has reasonable cause to suspect of having committed an offense under the bill, and to give certain directions asking the suspect not to operate the vessel or perform any designated duty on the vessel. Also, the ship owner or the master must arrange for a replacement to perform duty on the vessel, and the owner, agent, or master of the vessel must arrange for the suspect to be brought ashore immediately. The owner, agent, master of the vessel should also make sure that there is proper replacement to ensure there is proper operation of the vessel. Thank you. I want to ask about 3. If for this clause, one would be subject to a punishment of a fine at level 3 and to a imprisonment term of 6 months. So why are there lower penalties for someone who does not stop? Please think about it again. Alright, let's move on to clause 36. Thank you, Chair. Clause 36 relates to power to enter premises. It empowers authorized officers to enter any premises other than domestic premises, that is, non-domestic premises for specified purposes. It also empowers an authorized officer with a warrant issued by a magistrate to enter by force, if necessary, any non-domestic premises and any domestic premises. After entering the premises, the authorized officers may search the premises and exercise any powers given by the bill, for example, getting on board the vessel. We have referred to the relevant ordinances for this. Thank you. Any members from questions? If not, let's move on. Alright, clause 37 provides for service of a notice to appear before a magistrate in respect of an offense under the bill. Authorized officers can ask the suspect to provide information in order to issue a summons to them. For overseas seafarers, they may not have local addresses, which is why, in accordance with clause 37, they will ask the suspect to appear before a magistrate on time. Again, we have referred to the relevant ordinances when drafting this clause. Thank you. Any questions from members? Right. Can you explain what would be the time to appear before a magistrate instead of designated time award? Yes. Please. Turn on the microphone for him. Thank you. Chair. Thank you, member. If a prosecution is made on site, we'll arrest the suspect and we'll take the caution statement from the suspect. And a court summons will be issued. For ocean-going vessels, the next day they would have the suspect arraigned, and we will notify the agent Seafarer has been arrested. That is, the suspect has to stay in Hong Kong and be brought to court. And the seafarer will not receive bail in general, correct? Yes. Well, as long as we can locate that person, it should be fine. Well, we're almost time. I think we will stop at 12:45. I don't think we can finish all of them today. We still have 10 of them. I think we'll need another session for this. We shouldn't rush our progress. Alright, let's move on. Clause 38. Clause 38 provides for the use of logbook, etc. in evidence in proceedings. And in 38(1), it says that such evidence can be submitted to court to be admitted in evidence. Again, we have referred to relevant ordinances on this. Well, we now have electronic logbooks, right? Is that provided for in the bill? Yes. How should they submit such electronic entries? They can make use of soft copies. Okay. Alright. Clause 39. It is about proof of identity of the master of a vessel or of the person operating the vessel or performing any designated duty on board the vessel. The court must accept such document in the absence of evidence to the contrary, the statement as evidence that the owner or the owner's agent was the master of the vessel or the person operating the vessel or performing any designated duty on board the vessel. Alright, any questions? If not, please proceed. Thank you. Clause 40 relates to proof of identity of agent in proceedings. We have referred to Chapter 548 for this. The proof of identity of agent. Well, if one is appointed as an agent for the owner, that agent would be held liable, correct? Should there be any incident. That is, if one normally finds the owner guilty of something, if an agent is appointed, the agent would be held liable. Is that the case? Yes. Well, but we would only look at the registered owner or the agent of the registered owner. These are the ones that will be held liable. Well, I understand. If there's anything beyond that, we would be covered by other ordinances. Okay, please proceed to Clause 41. Clause 41 is on obstruction. It creates an offense of obstruction. It has referred to Chapter 548 and 313 for this. And the penalties are the same. Okay. Oh, Mr. Chen Su-hong, please. The speaker's microphone is not on. The speaker's microphone is not on. The speaker's microphone is not on. It says here a 2-year prison sentence will be provided, but for other offenses it would be 6 months. So for one, as said before, does not stop, they would receive a lower penalty than this. Is that really consistent? I think the chair would agree. Let's see what the administration says. what is the definition of obstruction? Thank you, Chair. Thank you, Member. About one not stopping, we can charge them with both obstruction and not stopping. So these are two separate charges that can be charged. So for example, if the one in operation of the vessel is directed by the master not to stop, then the master can be charged with two separate charges. Chair, I also want to ask, will the administration review the charges for not stopping the vessel? I think it should be clear to what extent it would be classified as obstruction, and when will one be charged for only not stopping the vessel. I think before, for not providing information, it would be a fine at level 4 and an imprisonment term. It's not as serious as this one. So I want to ask, when will it become obstruction? Thank you, Chair and Member, for the questions. For 41.1, it says any person who obstructs an authorized officer performing or exercising any function, duty, or power. It will cover more scenarios. For the offense of not stopping the vessel, that would just be about not stopping the vessel. For obstruction, it can happen after enforcement officers have boarded the vessel and there is some other form of obstruction. Well, I partially understand what you're understanding. There are other offenses provided for the obstruction of the provision of specimen, for example. So this obstruction would cover acts that have not been covered before. If you do not stop the vessel and in the end I let the officers board the vessel, I would only be charged with the lighter charge of not stopping the vessel. But now you say there is also obstruction that can cover that. So when will it be obstruction?
For example, when I bought a vessel and I'm going to take a specimen, if I am prevented by anyone, other seafarers may be surrounding me, may be obstructing me, then other persons will be charged with the offense of obstruction. Not necessarily the master of the vessel. Just assuming the master is operating the vessel but refuses to stop the vessel, it's the seafarers who are obstructing the law enforcement officer, and when you charge the master, then the master is still liable to a fine at level 2. Is that correct? Yes. So I should take it that it's all other kinds of obstruction. We can provide written replies to the Bills Committee after the meeting. It actually depends on different types of obstruction. Some will attract heavier penalties, whereas some will attract lighter penalties. We can give you further information after the meeting. Yes. Well, previously we did look at the offenses of varying degrees of obstruction. You can draw reference from that. Mr. Chen Xiu-hong. Thank you, Chairman. Right, indeed. in clause 34 bracket 3. And in the case of false instrument, misleading instrument, that still attracts a fine at level 2. It depends on the background. So you should think whether there is any consistency or protection offered. Well, we should save part 5 for the next meeting, just for completeness. Any more questions or clarifications that you need to seek from the administration? No? Agenda item number 2. Any other business? No? Next meeting is scheduled for the 7th of May, 10:45. Well, just a suggestion, Mr. Chen Xiu-hong. 2 bills committee are conducting meetings in tandem. Members need to go to another meeting halfway through this meeting. So, Chairman, can you liaise with the chairperson of other bills committees? If 2 bills committees are being conducted at the same time, probably the time needs to be adjusted. Well, I asked exactly the same question 5 or 10 years ago. The council's time is very valuable. We'll try to cater to the timetable of all members. We'll try our best. Meeting adjourned. Thank you.